This is Michael Popok, and that means it must be time for Legal AF After Dark. Why are we waiting on the Supreme Court of the United States again for a simple order confirming that Donald Trump doesn't have immunity from criminal prosecution for the things that he's charged with in the indictment in the D.C. election interference case? The D.C. Court of Appeals took a full month to render its decision, likely because they had to put together and synthesize into a coherent decision because you have 3 judges. Now we got 9 judges on the United States Supreme Court. Is the delay because they're waiting on 1 or 2 of them to write a robust dissent, but they're going to uphold the District of Columbia's ruling and find no immunity for Donald Trump? Or is something deeper and darker going on behind the scenes? You want to know more? Watch Legal AF. Here's the clip where we talk about it.
So Michael Popok, we know that back in December already, federal judge Tanya Chutkan rejected Donald Trump's assertion of absolute presidential immunity. She denied his motion to dismiss the indictment there. And just so you all see the track that her case was moving on and what we previously talked about with Judge Eileen Cannon, the indictment before Judge Eileen Cannon happened before the indictment before Judge Tanya Chutkan. Donald Trump is first filing the motion to dismiss indictments before Judge Cannon. And back in December, he had already been denied those frivolous motions by Judge Tanya Chutkan, just so you have, you could think about the pacing there. So then he appealed to the D.C. Circuit Court of Appeals. He lost there. We got an order a few weeks back there. And then they gave him, I think it was until February 12th, to file an application for stay pending a petition for certiorari, meaning ask the Supreme Court to still keep everything paused, pending whether or not the Supreme Court will accept oral argument on this issue of absolute presidential immunity, which they can just reject as well. It requires 5 justices to grant the stay, 4 to grant certiorari. So if you're going to get the 5 votes to grant the stay, you'll probably then get the 4. It's kind of assumed under it that will then grant certiorari for the oral argument. So it's kind of an all or nothing proposition, Popok, as I see it. Either grant the stay and grant certiorari, or reject the stay and send this back to federal judge Tanya Chutkan. Now, it should be a relatively simple order on the stay. It's usually, they meet on Fridays, so their 2 Fridays have now passed since they've had full briefing. And usually what you'll get on that following Monday, and this past Monday was President's Day, I didn't see anything hit there. So I was thinking, okay, are we going to get a Tuesday? Is usually just a 1 sentence, stay granted through date X, submit further briefs, or stay denied, case, to be remanded or sent back to, the circuit court or back to the district court for further proceedings. We haven't heard anything. I want to get your take on what you think is going on here, Popok.
Yeah, I think you laid out the roads properly. I think it comes down to either they are using this time, and again, to us, it's silent, but behind the closed wooden doors, there's things going on. There's the caucus of the Supreme Court justices. The clerks are working behind the scenes. There could be memorandums that are being circulated to try to convince the hearts and minds of other people. There's coalescing of the 4 votes or the 5 votes, and then these pieces of paper that you talked about. There's really 2 reasons for the delay, and I'm hoping it's one. I'm cautiously optimistic that it's the one I'm going to say now, which is they're going to reject the stay. They're not going to require any further briefing. They're going to deny the appeal in this way and leave undisturbed the D.C. Court of Appeals decision that there is no presidential immunity, absolute immunity for criminal conduct as alleged in an indictment just because the person happened to be president at the time. But what the delay is that there's at least 2 people that want to be heard in their dissent. And what we're waiting on is not the one-liner. We're waiting on the dissents. And the dissents, God, if I was a betting man, I would just throw it out there as Sam Alito and Clarence Thomas either writing separate dissents or joining together in one. That takes a minute to write. No pun intended. These aren't minute orders. These are things that take a little bit. Usually these guys crank out 5, 10, 15 pages of a dissent, and then they might try to circulate that to try to change hearts and minds. And if things are looking bleak for them, and either the 4 votes needed to even consider an appeal or 5 for a stay, then it'll just be the dissent. They'll try to see if they can grab another vote over to them, which, if I had a guess, it could be Gorsuch. That's what I think they're working on. They're working on these dissents, which is a good thing because that still means that if that happens, then the appeal, the stay, the interlock, all this stuff that's going on right now gets ended without further process, procedure, rigmarole, or oral argument, which would delay things another 30, 60, 90 days. And then it gets back to Judge Chutkan with a remand to get your trial back up and running. Within a day, she schedules a hearing, to a status conference, to bring the lawyers back in front of her and talk about the reset trial date, adding a couple of months on, because she said, just so we have laying the line in the sand, she's already on record as saying that 7 months is good for preparation. It's enough due process time for Donald Trump. Now, she told him, this is where they can, because the lawyers for Donald Trump are not, how do I put this? They're not the best lawyers in town, and they're not consistent with each other, and they're not monolithic. And sometimes one lawyer says something that undermines the arguments of another lawyer representing Donald Trump in a companion case. So Chutkan and the D.C. Court of Appeals both told Donald Trump, you do not have to be working on preparing for your trial in the D.C. election case. We don't expect that you're still working on it. You shouldn't be working on it. You've said it's a burden. We're going to take the burden away for you on the stay. And so Chutkan has taken that position. And he was about 5 months into prep. So my gut is she would add 2 more months and take us into June-ish, July, which was going to be her holiday. And then we get this trial, which will only take 4 to 6 weeks, up and running and done and in the can with a jury verdict prior to the election. The reason I said that there was already Trump's undercut his own argument is, I don't know if you caught this, but Todd Blanche, the lawyer for Donald Trump, told Judge Merchan in the New York Supreme Court case that's going to trial March 25th that they have been working on the DC election interference case, regardless of the stay, as an argument as to why he shouldn't have to gear up now for a March 25th trial in Stormy Daniels, because they didn't think that was ever possible, which is bizarre because Blanche was in the courtroom when the judge told him, I don't care about your primary season. We're picking a hard date. And here it is. It's March 25th. So, but in arguing that, he also undercut the argument. And I'm sure Jack Smith's going to bring to the attention of Judge Chutkan, if it ever gets back to her, they've been working. You don't have to give them much more time. Blanche just said they've been working on the trial as if they thought it was going. And so let's get this trial up and running as fast as possible. It's either what I just described, that we're waiting on dissents only, and the D.C. Court of Appeals case is going to be the ruling. And if Trump's got an issue, he can take it up after he's convicted, we hope, and after an appeal at the end of a case, like anybody else, like any other regular defendant. Or they're struggling, as we saw, when you and I were trying to figure out what is taking the D.C. Court of Appeals so long to do their which, by the way, 4 weeks to wait on an opinion that turned out to be, 68 or 70 pages of really hard-hitting, perfect analysis was not really that long, but we were getting impatient, obviously, for obvious reasons. But that the reason for that is, you could tell they were trying to coalesce around and to get a complete unanimous decision. And if there were any holdouts, they were working through that, as only judges can, in circulating drafts of opinions until they got a coherent decision that all three could join onto. So it's either what I just said on dissents, or there's still lobbying going on to find the 4 to take the appeal and or the 5 for the stay, and that is what's going on behind the scenes. But as a betting man, I think they're going to keep the D.C. Court of Appeals decision in place on the immunity. They're still considering, we haven't gotten the ruling yet there, the ballot banning 14th Amendment Section 3 case that you talked about earlier. I think they maybe at the same time, they let him be on the ballot, but they leave the absolute immunity thing in place to allow the trial to happen before November. And we'll just have to see if we're right. When we see dissents, we know I was right or we were right. And if we don't see dissents and we see something else, then they were working on something else.
Look, it is possible, though, that there are dissents that go in the opposite direction, where the court grants the stay and accepts certiorari, and then you have dissents explaining why the DC Circuit opinion made sense. Although, why that's probably less likely is you would be delaying and holding up the inevitable anyway. And if you were going to write that dissent, unless it was super kind of quick and concise, you're kind of lending to the delay. So why even do that, just rather than say you respectfully dissent? So that's why, Popok, I think yours is, more likely, because rejecting the stay has a little bit more of a dispositive impact than accepting the stay, in terms of what would encourage kind of a lengthy, unusual dissent in the circumstance. But again, what we're trying to do right here is the equivalent, to use the example we've given before, of tracking the weather patterns the way a meteorologist does to tell you if it's going to, snow, or if it's going to rain, or if there's going to be sunshine. And you don't always get it right, but we can look at those data points and share with you how we go through the data to try to make these predictions.
Well, welcome back. That's an example of what we do twice a week on the MeidasTouch Network on Wednesdays and Saturdays at 8 p.m. Eastern Time on a little podcast we like to call Legal AF. It's exactly what you think. 2 anchors enter, 2 anchors leave every week, twice a week. And you can help us get this network up to 3 million free subscribers by Election Day, by November, with your help, with your thumbs. It's all free. You already know that. Don't change that dial. You're on the MeidasTouch Network. If you like lawyers who know what they're talking about at the intersection of law and politics, you've come to the right place. We put together a show, Legal AF. We put together 4 or 5 news stories that we analyze as lawyers who know what they're talking about this particular matter every week. And if you like what we're doing already, thank you for being part of our audience. Take that clip, send it off to friends and family and say, hey, Legal AF, I love that show. Take a listen, and then maybe they'll join and make a full investment into our show. And if you don't know what I'm talking about, that was Legal AF. I'm Michael Popok, and I invite you to be part of our audience. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.